Hello America, my name is Tracey Rhodes and I'm an Army veteran. Americans assume that prosecutors are acting in fair and honest manner. However, America is experiencing the unjust use of governmental power to wrongfully convicted citizens, demonstrating a need for conviction integrity units. The administration of justice suffers when any accused is treated unfairly. Thousands or tens of thousands of innocent Americans are branded as criminals and sent to prison for an offense they did not commit, according to prosecutorintegrity.org article, An Epidemic of Prosecutor Misconduct. Prosecutor integrity statistics reference 2012 cases in the United States from 1970 to 2003 in which prosecutor misconduct affected the fairness of pending criminal proceedings or infringed on the constitutional rights of defendants. On November the 8th, 2013 in Texas, Ken Anderson, a former Williamson County District Attorney, failed to turn over exculpatory evidence and entered a plea to criminal contempt for deliberately withholding exculpatory evidence pointing to Michael Morton's innocence. The North Carolina State Bar disbarred District Attorney Michael Nifong for his dishonesty, fraud, deceit, and misrepresentation of the Duke Lacrosse University case in 2007. No one will know the extent of the prosecutor misconduct in Indiana in my case without investigating my complaint. I am taking the blue pledge to awaken the public of an unjust use of governmental power that resulted in wrongfully convicting me in Indiana and to blaze a new trail in the criminal justice system. The state of Indiana judicially raped me, and I need your help, America. The state of Indiana, by Howard County Prosecutor James R. Fleming, filed and reported fabricated, false, fraudulent criminal charges to Howard Superior Court 2 against Tracey Rhodes without probable cause in 2006. The state of Indiana used faulty eyewitnesses, perjured testimony, vouching, and illegal tactics to obtain an unlawful conviction. One specific example is on October the 19th, 2006, James R. Fleming, being duly sworn according to law upon oath, deposes and says that on or about February the 8th, 2006, at or near 1907 West Sycamore Street in Howard County, state of Indiana, Tracey Rhodes did compel Linda Schlechter to submit to a touching by force or imminent threat of force, to wit, touch with a penis, with intent to arouse or satisfy the sexual desires of the defendant, said act being facilitated by furnishing Linda Schlechter without her knowledge with a drug as defined in Indiana Code 16-42-19-2-1, to wit, various drugs, controlled substances, contrary to the form of the statutes in such cases made and provided against the peace and the dignity of the state of Indiana. The alleged criminal complaint is misrepresentative of the facts, and any reasonable person would have known the affidavit and the charges to be fabricated, false, fraudulent after reviewing the medical records. Linda Schlecter's surgery was on February 8, 2006, which is 77 days after St. Joseph Hospital and Health Center fired me. The hospital fired me on November the 23rd, 2005, my 37th birthday. In addition, Lee Schwartzendruber, registered nurse, signed the Phase 2 recovery room record, page 1, and the discharge instruction sheet. Susan Gregory, RN, signed the Phase 2 recovery room record, page 2. The medical records demonstrate exculpatory evidence, material to the point in question, with names of material witnesses who factually provided care to Linda Schlechter by clear and convincing evidence, clearly demonstrating to any reasonable person that it was not Tracey Rhodes. Exculpatory evidence which the Kokomo Police, the state of Indiana by Howard County Prosecutor James R. Fleming, and criminal defense attorneys Dan May and Zaki Ali reasonably received, failed to investigate, ignored, and withheld the evidence from the court to cover up the government's misconduct. In addition, the Kokomo Police Department destroyed the evidence on March 10, 2009 to cover up the malfeasant conduct. A Howard County prosecutor disregarded the constitutional rights of others, abused his discretion, and committed a gross miscarriage of justice with a dishonest or corrupt intent. James R. Fleming misrepresented the facts that is prejudicial to the administration of justice Therefore, he violated the 14th Amendment of the Constitution or laws of the United States, depriving me of due process and the equal protections of the law. Howard County Prosecutor James R. Fleming abused his discretion by filing charges without probable cause. He violated the Constitution or laws of the United States. He violated the Indiana Rules of Court for Admission to the Bar and Discipline of Attorneys, Rule 22. In addition, he violated the Indiana Rules of Professional Conduct, Rules 3.8a, Rule 4.1, and Rule 8.4. Prosecutors do not have a license to commit lawless conduct. Lawless conduct is oppressive, it is unlawful, and it demands an investigation in the interest of justice. Lawless conduct demands disciplinary action and appropriate punishment to deter future misconduct in Howard County, Indiana. I received an associate's degree in nursing from West Ark College in May of 1998. And in addition, I received an Associate's of Applied Science degree from Ivy Tech Community College, Central Indiana in May of 2014. I graduated magna cum laude, Phi Theta Kappa, and International Honor Society, and the National Society of Collegiate Scholars honored me by induction into their honor societies. I'm also a member of the Indiana Paralegal Association. Today I will demonstrate why filing blatant, fabricated, false, fraudulent criminal charges against anyone without probable cause is a reckless disregard for the constitutional rights of others. It's an abuse of discretion. Disregarding the constitutional rights of others and abusing discretion is prejudicial to the administration of justice and an unjust use of governmental power. Justice demands an investigation independent of the state, and in addition, I will discuss some reasonable solutions to improve the standards of practice in Indiana and abroad. First, filing criminal charges without probable cause is an abuse of discretion which is preventable by improving the standards of practice through disciplinary action, training, and research. For example, filing a criminal charge without probable cause violated the prosecutor's oath under the Indiana Rules of the Court for Admission to the Bar and Discipline of Attorneys, Rule 22. The prosecutor under oath did solemnly swear affirm that he would support and defend the Constitution of the United States and the Constitution of the State of Indiana. He said he will not counsel or maintain any action, proceeding, or defense which shall appear to him to be unjust. The medical records in this case clearly demonstrate material evidence of witnesses who factually provided care to Linda Slechter by clear and convincing evidence. The prosecutor or any reasonable person, after comparing the medical records to the complaint, would have known the complaint is fabricated, false, and fraudulent, and without any probable cause. The prosecutor's actions are dishonest and a mockery of justice. Mockery of justice demands an investigation and appropriate disciplinary action. The evidence demonstrates a need for additional education and training in identifying and reporting the disregard of constitutional rights of others. The evidence demonstrates a need for additional education and training in identifying and reporting the abuses of discretion. Second, filing criminal charges without probable cause violated the Indiana Rules of Professional Conduct, Rule 3.8a. The rule states that the prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Any reasonable person who reads the charging information and the medical records can see the complaint is fabricated, false, and fraudulent, and without probable cause. The prosecutor's violation demands investigation and appropriate disciplinary action. The evidence demonstrates a need for additional education and training of governmental employees, both city and state, in appropriately identifying probable cause in Indiana. Third, filing criminal charges without probable cause is a reckless disregard for the constitutional rights of others. It deprives due process and equal protections of the law. Depriving due process and equal protections of the law violated the Constitution or laws of the United States. It demonstrates by clear and convincing evidence a deprivation of civil rights resulting in loss of liberty, property, nursing license, income, and the ability to earn income. Such egregious deprivation of rights demands an investigation, demands a remedy, and demands policy changes. The evidence demonstrates a need for additional training and education in identifying and investigating the disregard for constitutional rights of others in Howard County, Indiana. The cause of the abuse of discretion is a personal bias of investigators who fail to investigate. Prosecutors who fail to investigate and ignore material witnesses abuse their discretion, act dishonestly, and misrepresent the facts and the truth. The failure to investigate is prejudicial to the administration of justice. Material witnesses can shine a light on what they actually observed in comparison to the criminal complaint. In this case, the medical records clearly demonstrated material witnesses who factually observed the care provided to Linda Schlechter. The material witnesses who directly and indirectly observed the medical treatment can reasonably impeach the complaint beyond any reasonable doubt. The state of Indiana, the city of Kokomo, the Kokomo police, and 2 criminal defense attorneys reasonably knew the exculpatory evidence existed. However, they withheld the evidence that impeached the complaint from the court. Withholding relevant and material evidence which clearly impeaches the charges is prejudicial to the defendant, and it's prejudicial to the administration of justice, demonstrating professional misconduct. Prosecutors who fail to investigate, ignore inconsistent statements in criminal cases obstruct justice. The state of Indiana used statements which are inconsistent to the degree that one of the statements is false, and they've committed perjury. False statements are misleading, dishonest, and a gross mischaracterization of the facts. False testimony is testimony known to be untrue by the witness and by whoever cajoled or coerced the witness to give it. Ignoring inconsistent or contradictory statements material to the point in question provided the state of Indiana with an inadequate factual base for a plea and conviction. In the criminal justice system, using false testimony, using trickery or deceit is an unjust use of governmental power. It abandons the truth, and it's prejudicial to the administration of justice. Solutions such as eyewitness identification, mandatory recordings, and evidence preservation policy changes are reasonable solutions. Eyewitness identification policy and procedure changes are reasonable. For example, police officers who are unaware of the suspect should administer the photo lineups. The lineup should include non-suspects in the lineup. Eyewitnesses should not view the same suspect in multiple lineups. The eyewitnesses should provide a statement articulating the level of confidence in the identification of the perpetrator. Changes in eyewitness identification policy and procedures improve the standards of practice, which reduce the risk of eyewitness misidentification and wrongful convictions. Mandatory audio and video recordings to investigate interrogations and confessions to law enforcement and to defense attorneys to anyone confessing to a crime is reasonable. Recordings improve reliability. Recordings improve the authenticity of the person making the confession. Recordings protect the people from law enforcement and defense attorneys using illegal tactics to secure false confessions. Recordings protect law enforcement and defense attorneys from false claims of misconduct. Recordings improve the standards of practice, which reduce the risk of misconduct and false confessions. Evidence preservation is reasonable. It is reasonable to secure and preserve physical evidence in each case. Properly maintain physical evidence in all criminal cases. Properly supervise the evidence as long as the defendant is incarcerated. Conducting proper DNA tests can reasonably identify guilt or innocence in each applicable case. Proper DNA tests can prevent false confessions. Improving evidence preservation can improve the standards of practice, which reduce the risk of misconduct and false confessions, leading to wrongful convictions. Today I've demonstrated evidence reasonably showing the abuse of discretion by a Howard County prosecutor, and I demonstrated the causes of the abuse of discretion and offered reasonable solutions to improve the standards of practice in Indiana and abroad. In addition, I want to remind you that Howard County has a history of judicial abuse. For example, Nancy Louise Botts is a person who was misidentified and wrongfully convicted on November the 22nd, 1934 of forging checks in Howard County, Indiana. She was sentenced to the Indiana Women's Prison. While Nancy Botts was in prison, the person who actually committed the crime confessed. She spent 2 years of her life in prison as though she was in fact innocent and the victim of a gross miscarriage of justice. No investigation, no disciplinary action, no policy changes were created to punish the wrongdoers, and no future deterrent of such gross misconduct was created. The case was not published, therefore was covered up, but may be reviewed at the Howard County Circuit Court Order Book 6 at pages 277, 281, 323, 324, 566, and 570. The case is the State of Indiana versus Louise Botts, number 3093. To learn more about the causes of wrongful convictions, you can visit theinnocenceproject.org, visit www.law.northwestern.edu/legal clinic/wrongful convictions, or you can visit truthandjustice.org. You can learn more about prosecutor misconduct at the prosecutorintegrity.org or www.innocenceproject.org/content. Former Williamson County Prosecutor Ken Anderson enters a plea to contempt for misconduct in Michael Morton's wrongful murder conviction.php. And you can learn more about the exonerated at www.law.northwestern.edu/legal clinic/wrongful convictions/exonerations. I thank you, America, for listening. I need your help and financial support to help pay medical experts, sex crimes experts, and attorneys King and Colbus to investigate the malfeasant conduct which created this manifest injustice. I need your help to initiate litigation and enforce disciplinary action. In addition, your help and financial support will assist in creating a nonprofit organization titled Let There Be Light to investigate and resolve wrongful convictions in Indiana and abroad. Thank you for your time, consideration, and contributions to help. Your contributions will make a difference to reach higher and achieve more. Your contributions will provide a light to ensure a healthier future for Indiana and America. You may send your financial contributions to King and Colbus, 120 East Market Street, Suite 410, Indianapolis, Indiana 46204. Thank you, America, for your consideration. I look forward to your response.